in full. That's our decision on the merits of the case, and hereby the technical side of the competition is deemed concluded. And I think that's least important, I think, part of the event, because now as judges, we think we should name the winning team of the event and also name the best speaker. And we have unanimously decided that the winning team will be the team of the claimant, who have prepared a better written document and were better in presenting their position in the oral exercise. Having said that, and I think, sorry, and the best speaker was Alexei Korol. That was the decision of the judges. So I congratulate you on that, but I would say that there were a lot of lessons to be learned for both teams, as I deliberately said that the team was not best and the paper was not best. It was better than the other, the performance of the other team, because neither of the, I would say, positions were absolutely ideal. And here I'm not, obviously we're talking about imaginary case, we're talking about imaginary facts, and the facts are not complete. So you all, both of the teams operate in a slightly artificial and imperfect environment. But what we as judges were looking for was the understanding of the principles of international taxation and your ability to identify those principles which are relevant and apply them against the facts and draw conclusions. And I think, again, that's something where quite a lot of work needs to be done by both teams, by representatives of both teams. Because I think also the impression we got that even where the claimant used good arguments, they were not necessarily rightly placed in the context of the facts and where they should be positioned in the logic. So that's something we can discuss in a bit more detail. But the main observation was, and I think when Vladimir Giderim, as a judge, was asking questions, at some point he effectively gave a free lecture on how to apply and how to apply the logic of the principles of international taxation to the facts. And I think that's something that we wanted to see more on both sides, both on the side of the defendant and on the side of the claimant. And the most obvious example, obviously, was and it's maybe a good time to ask, because I was under impression that you came up with a permanent establishment idea just last night, and then wanted to maybe surprise your opponents with that, because at the end, when you realized where it takes you, you effectively left it for the court to say, well, it's either permanent establishment or they are not beneficial owners. In any event, they should be denied treaty benefits. And that's not how you talk to the court in not in real life, nor in this kind of moot competition. You have to pick up a theory, test it against the facts, and if you are convinced with it, you have to try to persuade the court that you're correct, and not say that, well, it's either or, and we don't know, but please, court, make them pay taxes. I think this would be my main feedback, and my fellow judges, if you want if you want to give any more specific feedback, please do so.
I would like to mention that talking about procedural things, procedural rules of process or rules of procedure. I think it's in the Russian tax code, and again, I have no other tax law to refer to. The burden of proof lies on the tax authority in claiming that, in proving that the taxpayer has not, let's say, relied on a particular rule, basically as a basis for their rejection of a right of a taxpayer. Okay, in this connection, there is a domestic law rule about withholding tax, and there is a treaty entitlement of the taxpayer. So basically, you need to prove that the taxpayer is not entitled to claim the benefits because of this, and then you need to list those arguments and to present it to the court in a very logical way, like Alexander said, and you need to demonstrate how the law applies to the facts, right? So, for example, you have to say that the taxpayer, which is a foreign company from Asana, they have created a permanent establishment in Srivasana, and the income claimed under the treaty related or was attributable to the permanent establishment. That's why, based on paragraph 3, you cannot claim treaty benefits based on paragraph 2, right? And then here is our substantiation. They have a permanent establishment 1, 2, 3. The profit or the income is attributable to that permanent establishment 4, 5, 6, etc. Then you could potentially, you could have also said that even though we still claim this argument, but then in addition, we can still consider the beneficial ownership situation or the beneficial ownership status of a taxpayer, but as an additional argument. But as Alexander said, you cannot provide the court a menu. Either you take a soup or you take potato. Just pick up what you like. No, you could have said, and we have seen this in the court, but in several court decisions, by the way, both in Russia and outside. Like, for example, I don't remember the exact cases, but I saw this kind of various rules of arguments of various parties. You could have said, and by the way, in addition to the first argument, the taxpayer cannot even claim the benefits based on paragraph 2 because they are not a beneficial owner. And again, you need to say they are not beneficial owner because of 1, 2, 3. Now, you tried to do this, and I need to pay respect to the tax authority team. In your paper, you said they are not a beneficial ownership because beneficial owner of income because they lack substance. But I'm sorry, this is not exactly how the beneficial owner rule works, at least not in this international commentaries of OECD Model Convention. You had to say that this is essentially an anti-conduit rule, and then if the company is a conduit, then it needs the benefits needs to be rejected, right? And then your claim that the beneficial owner argument relates only to this 1.5%, it just doesn't have basis in law. I mean, the anti-conduit rule works either the taxpayer is entitled or not. It's black or white. I'm sorry. And then based on the facts of the case, it seems that the income is not leaving Asana as a jurisdiction. Either the first company, the immediate recipient, or its parent company seem to be the beneficial owner. So that one was lacking. But please, again, follow the strict logic. One statement needs to logically follow from another, like I already explained. For example, you say we reject the taxpayer's claim for withholding tax exemption based on, and then you need to tell the article of the treaty, and then you need to say they are wrong because of this 1, 2, 3. For example, they are not beneficial ownership because they're a conduit, right? Or income is attributable to the PE, and we think the entire income is attributable to the PE because 1, 2, 3. And you went to this representative office debate, which basically diverted you into a wrong direction, pretty much. So that's what I wanted to tell to the teams.
May I take say another view? So you're both the winner teams, okay, and you made it to the final, and my congratulations to both of you teams. And I think you don't know me. So I'm experienced 20 years as a professor at the German University Mannheim on taxation. And I mentioned that the case is quite complex, and it's hard to to elaborate on the business model. And that's a bit my recommendation. Say, if you practice, ask, what is going on. And I think what Vladimir mentioned is, you could have allocated all activities to the source country, but in order to figure that out, you had to deal deeper with the case, which was the description provided better arguments to the claimants, I would say. But again, congrats. It's a complex issue, and I wish you from my side all the best. It was interesting to have that discussion with you, and go ahead in your professional future.
I guess, colleagues, thank you first of all for such a tremendous game. That was very, very interesting. So a few comments from my side. So the case is intentionally designed in a way to have some arguments strong or not strong. It will never, I mean, the case in the moot courts, most likely you played like moot courts back in the time. But nevertheless, the thing is that it is designed with intention, just not to have at least any one groundbreaking, self-exhaustive, for example, argument that will break the position. Otherwise, the case would have been solved fairly easy, and so on and so forth. So the thing is that your task was to play around the argument. So, for example, this thing with, for example, with the professionals, like there are 40 people in a company, and let's say 8 of them are, let's say, only have a marketing experience. So both teams might play around. Let's say 8 people are, just 8 people out of 40. It's not enough. What is the purpose of the others one? What are other people doing in the company? Whereas at the same time, the opponent may say, wow, 8 people. Can you imagine what 8 professional marketing specialists can do with the company? Well, it is not certain what the rest are doing. For example, IT specialists, secretaries, whatever. This is a full company having due substance, for example. This is something you might play around. And well, as I have, let's say, the experience with the moot court since, I guess, 2006 even, so the general idea is having the structure and follow that structure. So, for example, you might have some strong arguments, and when you prepare, for example, for delivering the position to the judges, so you may start with a strong argument, and at the same time, for example, if the judge is not persuaded with something, you may say, nevertheless, there is alternative argument or additional argument. So, and it's supported by this certain point. And when I worked like with the other moot courts competition, I mean, there are some sources of law, for example, or legal ground with which you're working with. So you may just say, for example, okay, so this follows from the OECD, for example, commentaries, and that one also is supported. I mean, our understanding is correct. It's supported by, for example, the case law, the case practice. Here are the cases. So that's the strategy and the logic behind all of that. Just this, and the whole purpose is not just to show who is the strongest or the weakest team. At no case. So the main purpose of, for example, meet also the prospective the prospective managers of yours. Who knows? But in a foreseeable future, we might all appear to be colleagues. So. Just to have fun and be relaxed, but follow the structure, have the structure in your mind. I mean, if you will participate in the next year competition, so just consider that. Have the structure, have as much arguments as you have. Evaluate which, let's say, arguments in your position, and let's say the points are the weakest, and try to find, strengthen it a bit. But anyway, the case was not, let's say, black and white. It was designed with the due intention. So let that fact do not distract you. So well done. Well, I really like that job. So back in the years, I wouldn't think that I would have been done, let's say, even better job than you did. So excellent. Thank you so much. I really enjoyed that.
Yeah, and actually the only thing I may add to these perfect speeches and wishes, just enjoy, right? Be relaxed, be creative, and enjoy this time in your life. It was a perfect experience. You are finalists of this prestigious competition, right? And thanks to Ros-ИФА for the whole organization of this event. And in your further professional development, I assume you are going to be tax professionals. You will should enjoy whatever you want, since without enthusiasm it would be difficult to practice, especially in further years when you would start your career. So enjoy, be well prepared, and everything will be okay. Thank you very much.
And then it remains for me, after everything substantive has been said, congratulations to both teams, both finalists, both winners of the competition. And of course, we had to decide on one team in the end, but you did a great job. It was a hard case, and there are many topics which we probably haven't fully explored today, which makes international tax law really interesting. So thank you very much, and congratulations.
Well, thank you very much. And I will just say in the end that indeed it was a very enjoyable way to spend this rainy Saturday. And the case was indeed very difficult. And I'm sure that if we really had to resolve it on the merits, it's good that we are all on Zoom, because otherwise it may have ended up in a fight, because the case is really, really difficult. But you've done all indeed under the circumstances quite well, and I can imagine that doing it on Zoom added more complexity than being present in a courtroom and not being able to see the live reactions of the judges and so on. But in any event, well done. You are all in the beginning of your professional career. You are doing very well at that level, and just make the most out of it, take the lesson, and get even better for the future. Thank you very much.
Thank you all the judges for this interesting game, and thank you all the participants that you join this Moot Court. And on behalf of the President of and Secretary of Russian branch of International Fiscal Organization, I would also congratulate the winners, and just as a small award ceremony for this competition. I believe you can see now the presentation. So the winners and another team, you will be awarded with the IBFD books, and the winner will definitely receive a cup of this competition. All the participants will get the souvenirs from Ernst & Young company. And also, as a bonus of this year, all the participants, you can chance to become a co-author of one famous Telegram channel in Russia with more than 500 subscribers. It's called Международные налоги, so international taxes. And I will contact you later on with the all details. Thank you again.
And maybe participants can say their thanks to the mamas, dads, and to the whole country, their teachers, and so on. Please, you are heroes of this rainy morning, as Alexander said.
Yeah, actually, we've been looking forward to greet you, to say thank you for this opportunity to have such an experience. because every tax moot court is, like you said, it is also always difficult to find the most the team that is in a better situation. So both teams struggle with some issues, and they have to choose then or there or there the best and the weakest arguments, and they have to be able to present them in the most appropriate way in order to ensure the court to be on our side, or on the side of our opponents. Thank you very much for such experience.
Excuse me, Your Honors. Can you hear me? I'm sorry. As the representative of the other party, the party of the tax authority, maybe the tax authority is not a governmental body people are used to hear good things from. Nevertheless, I would like to say thank you very much for this beautiful opportunity. First of all, for the organization parties and for the judges, Your Honors. Thank you for thank you very much for the opportunity, for your time and your comments. I really hope that these comments, they will improve our maybe potential position and increase our chances in the future. I also want to say thank you for my team colleagues, because actually I'm not a judge, but still I would like to say that I did appreciate the teamwork, at least within our party. And I'd say that, guys, you're the best. Thank you very much. And there are several people that helped us, the experts, maybe you've heard of them, or some other guys. They are not the participants, but still we would like to say thank you for them. Thank you very much.
Well, if you let me, I would like personally thank the judges. I'm very sorry if I take a lot of your time, but I've been always an adaptive idea that the best way to learn things is to put your theory into practice. So that was the really great experience, because this Moot Court has been the best lecture on taxes I've ever had in my life. So thank you very much. I've learned a lot. I believe that during this Moot Court, I have really improved my tax knowledge, and I have to thank you for that. Thank you.
I also would like to say thank you for this great opportunity to show our knowledge of international taxation, and because I think we all love this sphere and want to develop us in this, in this sphere. And I would like to say thank you for your honors, for your advice, and for your interesting ideas, and it was really a great event for us. Also, I would like to say thank you for our coach, Nadezhda Kondakova. Help was really important for us, and we really appreciate you.
And well then, one last word. I would like also say thank you to our opponents, because the last two games between our teams were really great. Thank you.
So again, thank you everyone, and I hope next time we will meet each other in real life in MGIMO University in Moscow. So see you.
Thank you. Have a good day.
Thank you very much. Thank you.